Good evening. This is Rahul Reddy. We are live here from Houston, Texas, every Tuesday from 5 p.m. to 6 p.m. Central Time. Reddy Neumann Brown does bring in immigration updates, and we do take live questions. Along with me is my business partner, Emily Newman. Emily, what do we have today?
Today, we're going to be talking about the latest update in modifications from the Biden administration that seem to be geared toward benefiting the undocumented population. So one of those announcements that came with the previous announcement about helping spouses of U.S. citizens was that they planned on coming up with some process to make it easier for people to get waivers of the ground of inadmissibility based on unlawful presence for those that went to school in the U.S. And so the Department of State came out with their updates yesterday on that in their Foreign Affairs Manual. So we'll talk about what that entails, who might qualify. And then very common question that we get is, how do I switch from an H-1B to an H-4 EAD? Maybe there's a layoff situation and your spouse happens to also be on H-1B with their approved I-140. So how can you switch to H-4 and get an EAD as quickly as possible to be able to get back to work and find a new job as quickly as possible? And then how to get back to H-1B in the future? What are the restrictions and limitations on that? What does the timing look like? And lastly, we want to update you on the new flag system, which is used for labor certification instead of the PERM system. We are down to the end of the old legacy system and getting approvals now in the new system. And so what does that look like, and where do we go from here with this new system?
Emily, waivers for the inadmissibility does apply for the people who are not legally present in the country, but also it applies for the people willful misrepresentation, or it's only for unlawful presence, this particular waiver?
It is for the 212D3 waiver, which is for all non-immigrants, and that waives most grounds of inadmissibility for non-immigrants, so temporary visa holders. It has nothing to do with being able to get the green card later. So yeah, I suppose it could work for misrepresentation as well.
So for example, if somebody has done some wrong things and they've been barred for coming into the United States, they could apply for the waiver application. It was taking a long period of time, especially they have to apply in the consulate though, but they don't do that. I mean, it's taking a long time when we apply the consulate. How fast do you think so this administration is going to take it? Will they get it done in 2 weeks, 3 weeks, or is it going to take?
I don't have high hopes.
It's going to be less than 2 years, but how long it will take with this new administration though?
Yeah, I mean, so let's use the example of the international entrepreneur rule that there has been some updates about recently, and how much I think that was from the Obama administration, if I don't recall, but we're trying to promote entrepreneurs and give them parole, and it took them 4 years to approve 26 applications. So what are they going to do with all these waivers? They can't handle the waivers that they already have, and now you're going to expedite all these new waivers for the how many million undocumented people who went to school in the U.S.? I don't have high hopes, but we'll see. So what do you need to be able to qualify for a waiver? In general, anyone who's applying for any type of non-immigrant visa, A, B, C, D, E, F, G, all of those non-immigrant visas at the consulate, you always have to prove that you are admissible. There are certain grounds of inadmissibility. The most common one that applies is unlawful presence. If you've been unlawfully present for more than 180 days in the U.S., there's a 3-year bar to being able to get that visa to come back. If you've been unlawfully present for more than 365 days, then it's a 10-year bar. So this waiver will waive that ground of inadmissibility to allow you to apply for the visa before you meet the 3 or 10-year requirement. And in order to qualify for this waiver, you have to, the consular officers want to look at how long ago did the issue happen, how serious was it, the reason you're now wanting to come to the U.S., the positive or negative effect that your planned travel will have on the U.S., whether this is just one incident that caused the problem, or is it a pattern of misconduct? And do you show that you have reformed or rehabilitated from whatever the issue was? So again, this could be for a criminal violation, this could be for unlawful presence, for a misrepresentation. All of those can be waived using those 5 criteria. What's different now is the consular officers have been instructed that if the person applying for the waiver has graduated with a U.S. degree and is seeking to come to the U.S., to come back to the U.S. to commence or continue employment in a field related to that degree, that is considered to have a positive effect on the U.S. public interest. So that 3rd criteria I mentioned, the positive or negative effect of your travel on the U.S., they will consider that as a positive criteria, which means you're more likely to get the waiver. On top of that, they look at whether the officer is going to recommend the waiver. One of the things they look at is, would your admission to the United States advance a significant U.S. public interest? And they specifically say that the positive effect of that planned travel for those that have the U.S. degree is a significant U.S. public interest that would be advanced, and therefore officers should be recommending this waiver to people who qualify. And then lastly, when you do apply for the waiver, it goes to the Admissibility Review Office, which is a different agency or different office. They're going to specifically expedite these particular waivers for people who have earned the U.S. degree and are coming to the U.S. to work using that particular degree. So as you mentioned, what is an expedite going to look like? Is it going to take 2 weeks instead of 2 years? I doubt it. Maybe it'll take 6 months instead of 2 years. We'll see. But that's the change that's happened, and they just announced those updates yesterday.
Question coming, Emily, on this is that, hey, right now it looks very certain that Trump is going to win the elections, at least to some of the audiences, which seems to be some reasonable thinking. Whether or not somebody likes or not, but that's a different issue. Will these things will have any negative impact what Biden administration is passing right now? Will Trump administration reverse all these things immediately, or will not reverse?
I mean, we saw some reversals of things when Biden came in. Things that Trump had done, but I was kind of surprised with how slow those reversals happened. So I think that the Trump administration is going to be prioritizing what things they want to undo first, and this might be pretty low on the list. So I don't know if they would completely undo it, if it would even be on their radar, because it's a pretty minor tweak to the existing way that waivers are done. It's not giving everyone a waiver, so it doesn't really change anything. So I don't think it would make a difference, but there are certainly other things that Trump could go after, like H-4 EAD again. I'm sure that's up there on the radar. Changing H-1B rules to make it more difficult to get an H-1B, changing the wage requirements, changing the lottery requirements. I think all of those could be on the list.
Can you try to reduce the voice a little bit, Emily? There's some echo coming from...
I turned it down already. It's about as low as I can go. Otherwise, I can't hear you.
Sure. Coming to the topic of switching to H-1B to H-4, EAD and returning back to H-1B, a lot of people have apprehension that once you go to H-4 plus EAD, you want to come back on H-1B or just H-4. If you want to come back on H-1B, you have to go through the lottery system. The answer is straight no, no, no. You don't have to go through the lottery system. You can, if you have any time left out of the 6 years H-1B, from H-4 back onto H-1B, you can back to H-1B. You can go. You don't have to go through the lottery. Let's say, for example, you use 4 years of H-1B, and you are trying to come back to you move to H-4, and then you're trying to come back to H-1B. You can come back, and you can come back and use the remaining 2 years of the H-1B. While you're on H4 EAD, can you file a labor and I-140 application? Absolutely, you can. And once you are done with that, once you get an I-140, you can come back to H-1B. You can even file a I-140 application when you're on H4 without an EAD. You don't have to be working with a company to file a PERM. You don't have to be working with a company to file an I-140. The companies, if they have a job offer, can still come into uh, uh, can uh, can still come back into H-1B without any trouble. Lot of and I-140s can be filed when you're on H4 plus EAD. It's very easy to come back. You don't have to leave the country. You can apply for the change of status within United States without leaving the country. Absolutely not a problem at all. Let's discuss about this PERM labor certification, Emily, that there is a new flag system that came into effect on June 1st of 2023. Until May 31st of 2023, it used to be a legacy old system. From June 1st of 2023, a new system came out. And obviously, until about July 10th of 2024, we haven't seen any PERM labor certification approval from the new from the new system that we have. Now we started seeing labor certification approvals from July 10th onwards. Are there any labor certifications that were filed before May 31st that are still pending in the system, Emily?
Not for those that were straight approvals. So anything that was filed and approved without audit, those are all done. But we do have cases that were audited that are still in the old system.
So in other words, everything which was filed by May 31st of 2023 were either approved or there is an audit that happened on that according to our records. But if there is anything else somebody finds out, please report to us. This is our information that we have based on our filings. All the PERM labor certifications that have been filed before May 31st, if there is no audit for it, they all got adjudicated by this time. And from July 10th onwards, we started seeing the labor certification approvals for the cases that we filed in the month of June in the new system. This is a new system. June of 2024, June of 2023 is a new system. We started seeing approvals. We were a little bit skeptical how the Labor Department is going to act on it. Seems to be okay right now. Hopefully so, they can progress it. Are there any new, how does the new labor certification approval look like? Or do you see any problem in this transition, Emily?
Yeah, it does look different. I will say the nice thing is the font is huge, so it's really easy to read it for us old people. But what's mainly different is when they created the new system, a nice thing they did was allow the prevailing wage information to be directly input to the labor certification without us having to do anything. What goes on the prevailing wage determination is all of the details of the job title, the work location, the minimum education requirement, the degree field that's required, the years of experience that are required, any special skills, certifications, or licenses that are required. All of that goes on the prevailing wage determination. And in the old system, we would also type all of that into the labor certification application. So when the application got approved, all of that information is on the form. Now, because the two are linked together, when you get the approval, it does not have any information about the job. It just says, here's the prevailing wage determination number. It does not say what the education is that's required. It doesn't say what field, does not say how much experience, does not mention certification, special skills, licensure, or anything like that. And then the approval that I'm looking at in front of me is 17 pages long with a whole bunch of blanks on it, but there's no information about the job itself, about what it requires. Now, when USCIS is adjudicating the I-140, the first thing they look at is, what does the job require? What's the degree required? How much experience is required? Because you have to submit your education documents and your experience letters and your certifications to prove that you qualify for that job. So how is USCIS going to know what the minimum requirements are if they're not actually on the labor certification form? Is USCIS aware that they've even made that change? I doubt it, because they've not come out with any guidance on how to file an I-140 with this new version of the PERM approval. So what we're planning on doing is printing out the prevailing wage determination that goes with the labor certification and including both of them in our I-140 petition. We don't know if that's what USCIS is wanting. I have a feeling we're going to see rejections in the mailroom when we file these I-140s for the first time, at least until USCIS gets on board. That's what happened during COVID when the DOL started emailing the approval notices and they didn't come on the fancy blue paper anymore. When you filed with USCIS, they were rejecting, saying this is not an original labor certification. Well, we know it's not, but DOL said we could do it this way, and USCIS was not on the same page. So I have a feeling something like that's going to happen again.
Any other things before we go to question assembly?
I think that's it.
Nirvana has this question. I have, it used to be a flexible work before, where going twice a week to office. Is it twice a day? Most probably twice a week to office, and to fully remote right now. Will that be any issues with the PERM application? No, we don't see any issues with the PERM application. Absolutely not a problem at all.
Gulam says, my company filed a PERM in the EB3 category for a position requiring a bachelor's degree and 2 years of experience, but I had 5.5 years of experience at that time, with 1.5 years at the sponsoring company, and now I've been promoted. Can I use the same PERM to file an EB2 I-140? No, unfortunately, because your PERM is only requiring a bachelor's +2. That job can never qualify for EB2. It only qualifies for EB3. So the only way to get into EB2 now is a new PERM or NIW, self-petition, and avoid PERM altogether. Or that new exceptional ability, the other Schedule A, you could potentially do that.
Lucas has overstayed on a student visa, and he has two children, 15 and 18. I'm assuming they are on F2 visa. If he gets married to a US citizen, can the US citizen petition for him and his children? For you, they definitely can. For a child who is 15-year-old, they can. I do have a doubt about the 18-year-old kid, whether they can or not, because the step relationship need to be established under a certain age, but I don't remember what age it was though. For sure, you and your 15-year-old child, they can. 18-year-old, I have to check. I'm sorry, I don't have the information right now, Andy, right now.
Mama Pova says, if a student in F1 is admitted to a particular university and wants to transfer to another university in the same state, can they do that? And what are the steps? Yes, that is doable, assuming that you've entered the US, you're in F1 status, you've reached out to the university that you planned on joining and started that process with that school. And then later you don't like it, you've taken some classes, you decide you want to go to a different school, you reach out to the new school and they will put in a request to transfer your SEVIS record from the old school to the new school. The old school will release that SEVIS record. The new school will then issue an I-20, and then you can just start at the new school whenever that program starts. You do not have to travel, assuming that you are maintaining your F1 status properly.
It's me, Davin. This is a YouTube person. He's asking a question. Can I apply for H4 EAD for my daughter and my wife, assuming that your wife is eligible for, based on your I-140 approval or probably PERM pending and 7th year H1B? Can you apply for your wife? Absolutely, you can. Can you apply for your daughter? No. H4 EAD is only for the spouse. It's not applicable for the child.
Rajiv says, can a person with an approved I-140 by NIW come to the US after finding a job? like a candidate with an approved I-140 in the EB2 category. So no, whether it's regular EB2 or NIW EB2, an I-140 approval does not give you any work authorization. It doesn't give you any authority to travel to the US even after you find a job. So you need a non-immigrant visa. You need to be sponsored for a work visa by that company, get that approval, get the visa stamp, then come into the US. The I-140 can then only be used later to file for adjustment of status to get the green card, but it does not provide any work authorization or benefit.
Raj Burma is having a question on the birth certificate. Name should be first name, last name, which one should be first? In India, though, it's very confusing. Each state has their own rules, especially when these birth certificates have been registered. That was a long time ago. Some uncle or aunt just went and registered those things. Things didn't went through very smoothly, though. So they do allow a lot of flexibility, though. If the first name has been switched to last name has been switched to first name, and sometimes last name is not even appears at all, and sometimes the name doesn't even appear at all. There have been a lot of flexibilities. I mean, because when the birth is reported, though, and some of the parents, they don't name the child, they wait until a certain period of time. So when the birth is registered, it's registered with no name at all. We have still presented it with alternative documents like Aadhaar card, PAN card, ration card, election card, and some certificates, school certificates, and they did take them into consideration. There is a lot of flexibility available as long as the birth date is properly registered, though. If the name is switched here and there, certain times things are added, words are missing. USCIS has been very flexible on it, though. But if the date is wrong, definitely that's going to create a problem.
Lewis says, my EB2 petition has been pending since September 2022 and has that case remains pending status for more than 7 months, even though the priority date's been current for 6 months. When would it be resumed to process? And when can I seek your services for USCIS request? It's definitely past time that they should have started working on that case if your priority date's been current for 6 months or more. After that, getting that case remains pending status. The best thing you can do at this point is litigate and do it now before the end of the fiscal year comes September 30th. You can speak with Stephen Brown in our office. He'd be happy to guide you on that process.
Can a person with approved I-140 under NIW, can they come to USA finding a job based on the I-140 approval of the EB2, which is NIW? The answer is, especially if you're an Indian national, though, the priority date is backlog. If the priority date is not current, and if you're planning to come here into the United States on NIW I-140 approval alone, that does not allow you to come into the United States. It only when the priority date becomes current, which is backlogged very significantly. So there are other visas available. Of course, you know the H-1B, where you have to go through the lottery system. L-1, if you're eligible for, if your company is eligible for, or O-1 is another visa that you may consider yourself. It has some flexibility with regards to the employer issue. So O-1 visa, especially if you've already got an NIW, you may fall into the category of O1, you may consider that option too. But I-140 standing alone for Indian nationals, when the priority date is not current, you will not be eligible to come into the United States on that alone.
Pranjal says, I got an RFE when I upgraded my case from normal to premium for an I-140, and the employer replied to the RFE after 3 months. How much time will it take for the decision to come? The RFE was responded to 6 days ago. Depends on the type of I-140. There's 2 different time frames, and the time frame starts when the RFE response is received by USCIS. So it's either going to be 15 business days if it's an EB2 or EB3 PERM-based I-140. If it is an EB1C I-140 for multinational manager or executive, it's 30 business days.
Muthu Kumar has this question. My spouse GC PERM has been filed in March 2024. Her 6 years is expiring in January of 2024. Is there a chance it may be approved by December 2024? Very unlikely. He's asking, what are the options available? Can she go to Canada? Yeah, if the company allows her to go and work in Canada and she has a work permit in Canada, that's something that you may want to consider. She can move on to B2 visa for a while until I-140 is approved and come back to H-1B. She can move into F-1 visa and later on come back into H-1B once the I-140 is approved. And if she has a H-4 option, definitely that is the best option that's available to you. And if there is a H-4 plus EAD option, that's even much better option that she can consider that into. Or there's another also option that you can think about is that can she spend some time outside the country? Can she spend some time outside the country? For example, if she goes in India, spends 2 months or so, then she can, if the company allows her to remotely work from India, then she can extend the H-1B based on the 2 months that she has, because it's been filed in March. She can extend it H-1B. That's available. So there are multiple options that are available. Muthukumar, it would be better that if you consult a lawyer in advance, so that based on your specific needs and how the company is going to react. Because the most important person in this one, the most important thing in this one is your company. Is your company willing to go forward with the labor certification and I-140 approval if there is a break in employment, if they're allowing you to work in the remote jobs? So there are all things will depend on the employer and the flexibility that your wife may have to move into other visas like H-4 plus EAD and other options.
Krishna says, with this new waiver, will the people who are barred from entering the country due to multiple filings be allowed to enter and work in the U.S.? Potentially. So the waiver would work for those people if they can meet the requirements. So if they have the U.S. degree and they've been sponsored and they're coming to work in the U.S. using that U.S. degree, that's just one of the criteria that shows that they will have a positive effect on U.S. public interest. They still have to get over the hurdle of the recency and seriousness of what they've done, the reasons why they plan to come to the U.S., whether this is a single isolated incident or they have a pattern of misconduct over the years, and whether they are able to provide evidence that they've reformed or rehabilitated after they did that. So just because they have a U.S. degree and just because they changed this waiver requirement for those people doesn't automatically mean they qualify.
Muthukumar is asking a question. When is it expected for my wife's PERM to be approved? She filed in March 2024. I want to plan it as if that it's not going to be approved by March 2025. Because by March of 2025, she will be eligible for the 1-year H-1B extension, even if the PERM is not approved. I want you to plan for it. And if by any chance, luckily, if it gets approved before March of 2025, she'll be fine. Now, under the normal circumstances right now, when we see that we are getting approvals of the cases filed in June of 2024, so it's expected for her to get it approved in April or maybe May of 2025. But once she touches March of 2025, then she's eligible for the H-1B, because based on the PERM pending for more than 1 year, she would be eligible for the 6-year H-1B, even if the PERM is not approved.
Dheeraj says the H-1B grace period end date and the I-20 program start date has a gap of 15 days, but I filed the change of status to F1 within the 60-day grace period. Will it be a problem for the change of status? So you not only need to look at the I-20 program start date, but there's an earliest admission date that's usually 30 days before that. So if that's the date you're talking about that has the 15-day gap, you may have a problem. But if it's the actual program start date and your earliest admission date is 30 days before that, that means there's no gap at all. You actually have 15 extra days and should be fine. So you need to look at which exact date you're talking about.
Amar Kazi has this question. Do I need to wait for 1 year before writ of mandamus if the 485 is pending? Or can it be done earlier though? If you have some special circumstances, then I would recommend you can go for writ of manibus before 360, before 1 year. But if you don't have special circumstances, though, I would recommend at least wait for 1 year before you go for writ of manibus, though. Special circumstances. What are special circumstances? If you're falling into EB1 criteria, probably that may consider to be special circumstances. There are some other special things where you can look into it, but the number one thing is I'm looking into EB1. The USCIS, the courts may look a little bit differently, though. But you can always have a free consultation with Stephen Brown if you want to, only if there is for a delay litigation. His email address is steven@rnlawgroup.com. You know, we have our law firm name right now is Reddy Neumann Brown, and this is Stephen Brown is one of the partner in our office. You can drop an email to him. He will be glad to speak 5 to 10 minutes to see if you meet the special requirements for the delay litigation of the I-485 application.
Narendra said, is there any option to apply for a change of status after a petition is filed as consular processing for an H-1B, and what will be the consequences regarding the process? So assuming that the H-1B is already approved in consular processing, the company just has to file it again and request a change of status this time around, assuming that you're maintaining your current non-immigrant status. And it has to be the same company if this is your H-1B cap subject petition. But it's not really a big problem. It's just the company has to pay the fees again and pay a lawyer again. So it's not so it's up to the company if they're willing to do that. Monica from Facebook says, if I apply for an F1 for my daughter and my husband's H-1B extension got denied, what are the options? Do we have to apply for a B1 parallelly as the F1 is in process? So assuming that your husband was in H-1B status at the time the F1 was filed, and your daughter was therefore in H-4 status at the time her F1 is filed, she's fine. The H-1B extension that later gets denied has zero impact on her because the change of status to F1 has already been filed. She's already in a period of authorized stay and no longer relying on her H-4 status. The rest of the family, if he's not able to get the extension approved, would need to look at filing a change of status to B2 or possibly any other type of visa category.
Sai Learn has this question. My current employer is going to file the PERM this year. Can I switch the companies while it is in the process? Yes, your company can continue the PERM process even though you left the job. They can. Will they do it or not? It's up to the company, though. You have to check with the company. Will they continue with the PERM or are they going to stop the PERM? It may be dangerous, though. If you know the company, they're going to do it, then it's fine. You can move. Otherwise, there is a good chance they're not going to continue with the PERM application.
Tappan says, my I-94 expires August 3rd, 2024 due to the passport expiration, but my H-1B is valid to September 2025. Meanwhile, I've been laid off. Do I need to get my I-94 updated or will it auto update? What are my options? Number one, it does not auto update. So your I-94 is expiring August 3rd, 2024. It is not expiring September 2025. That's super important because the 60-day grace period is cut short when your I-94 ends before the 60 days. So if you were laid off today and stop working tomorrow, your grace period is not until September 16th. It's till August 3rd because your I-94 is expiring. So you may want to work with your employer to see if they can delay your termination date to allow you to travel and re-enter while you're still working to get the extended I-94, and then they can do the termination. Otherwise, you need to take action by August 3rd in order to remain in status.
Emily, I want to discuss something very serious. a lot of people are asking the questions about the administration change that is coming up. At least most people are predicting that it's going to come up with. Now, as we know that the new administration is not going to be friendly, even though they made some statements saying that, okay, we're going to attach the green card along with the degree certificate, which they didn't substantiate it at a later date. Now, is there a chance that this administration might take some drastic step on immigration that cannot be reversible, though? For example, one of the gentlemen is asking here is that why not add a temporary protected status EAD for the people who are backlogged countries?
Yeah, I think the difficulty with anything that the president does is it can always be undone by the next president. How it gets undone and how long it takes to get undone is going to depend on how the change was implemented. If it was done through the regulatory process, which definitely takes time, that means the new administration has to go through the regulatory process to undo it. So it's going to take even more time for them to undo it. That's how the H-4 EAD was able to survive the Trump administration. So unless it's something that Congress actually does, it can easily be undone by any future administration. Just have to go through all of the hoops, the right hurdles to get it taken care of, unfortunately.
There are some like deferred action, also called as DACA, Emily. The Obama administration came in, and the Trump administration tried to undo it, and the courts blocked it out. Is that right, Emily?
Yeah, I mean, they blocked some of it. They blocked new people, but he blocked new people from being able to file, and that was successful. But he could not undo old people renewing. So, yeah, it kind of went both ways with that. He definitely was able to undo some of what the Obama administration did, even with DACA.
But mostly, would this administration be willing to grant something like EADs to the people whose I-140 is approved? Now, if they are in a reality check, they should be knowing that they are not going to come to power right now.
Yeah, I don't know. I don't feel like this administration has any plans to do much of anything for employment based or anything to do with the backlog. If they were to do anything, my guess would be for the legal dreamers, those kids that are stuck in the backlog that are aging out. That's the only likelihood I see, other than potentially not counting the family members, because that's more of an interpretation than an actual regulation or policy from USCIS. I don't know. What do you think?
They're doing a lot of favors to the people who are undocumented, Emily. I haven't seen much favors getting done to the documented. Even though the recent publication on July 15th by the Biden administration to expedite the waivers, it's mostly intended towards the people who are not in legal status, rather than the people who are in legal status. So even though it may incidentally benefit some of the people who might be in legal status, but mostly it's intended for the people who are not in legal status. This administration has not shown any sincerity towards the legally admitted status. Having said that, they did some favors to the people who are legally admitted. For example, 5 years of EAD approval. That's definitely is a good step towards the 5 years of EAD. 540 days of EAD extension when the extension is pending. They have done some slight favors. They are more administrative favors, but when it comes to the employment authorization, they haven't done anything yet to the people who maintain the non-immigrant status, the people who pay the taxes, the people who stay legally in the United States. They haven't done much favors to them, except some administrative, some kind of technical things, but nothing to do with the way they did for the undocumented aliens. Yeah, I mean, we may see some surprises, but I'm not expecting things to get changed between November and January, Emily, because that's when we will get a result and then we get a new administration. They may pass on some regulations They may pass on some executive orders in that period of time. I'm not expecting between November and January, but I may expect some from now to November. Hopefully so.
Yeah. Christina says, USCIS has rejected my H-1B extension application 3 times due to improper filing fees, even though my lawyer confirmed that the fees are correct. Do you have any experience or advice? It could be that the lawyer is correct. We do see USCIS improperly rejecting things, all kinds of different things. Like just we were talking about in our attorney meeting this morning that they rejected one of our H-1B filings saying that we didn't include any filing fee checks, even though we included the filing fee checks. But they didn't, when they sent the package back, they didn't include the checks with it, and they cashed the checks. I've never seen that happen. So I'm not sure.
Emily, was it cashed by USCIS? Did you check?
Yes.
Cashed by...
Yeah.
Well, I'm
so
not
we're
sure.
trying
Maybe
to
somebody
figure
stole
out,
the money.
Yeah, and the filing fee checks don't have the receipt number on the back anymore. So how are we going to get them to attach this petition that we resend without checks to the checks that they cashed? I have no idea how that's going to work, but it could very well be USCIS. At the same time, a lot of lawyers are very confused about these filing fees and keep getting them wrong. I see so many messages on the message boards saying USCIS rejected my thing. These are the filing fees I said, isn't it right? And people will be like, no, you forgot the asylum fee, or no, you paid the fees for small employers, not the fee for large employers. So there are lawyers that are making mistakes on these fees, not realizing it, not intentionally for sure. It's very confusing. We had all these different checklists with different boxes to verify. It's like trying to launch a rocket to figure out how to file something right now between the filing addresses and the filing fee checks. It's so confusing. So yeah, have them double check that they're including everything. And at the same time, if the fees are correct, but the form is missing a box being checked, there are questions on the forms that say, do you have 25 or fewer employees? If they said yes, but they send the filing fees for large employers because they actually are a large employer, that's going to cause a rejection. Even though it's a simple yes/no question to check a box, that alone will cause a rejection. So there's 3 different places where they can mess up those boxes. So that could be part of it as well.
Jesuda has this question. Her husband got laid off. She's on H-1B. She's planning to travel. If your husband files a H-4 right now, and then you travel while the H-4 is pending, absolutely not a problem. I'm assuming that you still have the job that you are on the H-1B, and even though when you're traveling, once you come back, you will get to the job back again, then absolutely your travel will have no negative impact in getting the H-4 approval for your husband.
Arvind says, I got a new offer and got my H-1B transferred to them, but now I don't want to join them and I want to continue with my current employer. Will there be any complications, any legal issues? No issues at all. So just because a company filed a transfer for you and got it approved does not mean you have to join that company. If you stayed with your current employer, you can continue to stay with your current employer. The transfer has no impact on that.
Banu has this question. He has filed I-140 and 485 in concurrent filing, and in I-140 was filed in premium processing. He got an RFE, and they responded to that RFE. How long does it take for the decision? It takes between 2 to 3 weeks for you to get a decision. Even the RFE will be counted towards the premium processing. So once you respond to the premium processing, they will take the premium processing time will start counting again. So they will have to give a response to you within 3 weeks.
Shailesh Chandra says, I was laid off during June when I was on H-1B, but I also have an EAD based on my EB-1B. But my I-9 was never updated with the EAD. What happens when the 60 days ends? What happens when the EB-1B dates are current? So the I-9, what document you used, has nothing to do with anything. That's a completely separate, that's just for the employer to verify that you have some kind of work authorization. It does not control what your actual immigration status is. So you are on H-1B at the time you were laid off. So if by the end of 60 days you have not filed an H-1B transfer or have not filed a change of status to any other type of visa, you are out of H-1B status. You still have a pending 485 and you can use that 485 EAD to work. However, how does that impact your 485? The 485 does not have a 60-day grace period. You're supposed to have a job offer at all times when you have a pending 485. And to keep the 485 going, you need to have a job offer from a new employer. The timing of that job offer really depends on where you're at in the process. Is there an RFE asking for a supplement J? Do you have an interview coming up? But you should definitely speak with an immigration attorney to understand how it impacts the 485.
Questions coming on EB-1A that I have an EB-1A approved with my previous employer. My current employer is telling me to file an EB-1A again. Do I need to file it? We don't see a reason for you to file an EB-1A. If you have an EB-1A approved previously, you can still use that to file the 485 application. EB-1A is given for your ability, of extraordinary ability. Even so, I don't see a reason why you have to file an EB-1A again. You can still use the old EB-1A application.
Arvin says, my employer lost the H-1B approval hard copy. When I travel outside the US, can I still get my stamping done with a soft copy? Yes, thankfully, now that all of the consulates use the PIMS system, they're able to look up your approval notice and you never need the original. The only people that ask you for the original nowadays are the driver's license, which has nothing to do with your immigration status, but it's silly.
There's another question with regards to EB-1. I got my EB-1 approved. Is it necessary for me to stay with the company? We need to know whether or not the EB-1 is EB-1A or EB-1B or EB-1C. Definitely, if it's the EB-1B or EB-1C, that EB-1B and EB-1C belongs to the company. It doesn't belong to the employee. So if you move out of the company, though, you have to file, especially EB-1B, you have to file one more time EB-1B. When it comes to the EB-1C, though, if you move out of the company, most probably you will not be eligible to file the 485 because the new company may not be eligible for filing EB-1C because of the relationship the company must have, that you must have worked outside the country for the same company outside the country previously before coming to the United States. You may not be eligible to file an EB-1C. Now, when it comes to EB-1B, when a person who is outstanding researcher then moves from one company to another company, they may be eligible to file for one more time with a different company. But EB-1C people, 98% of the time, they will not be eligible to file with a new company.
Abhiraj says, can I continue to work on the H-4 EAD if my H-4 is expired and the application is pending? No. There is an auto extension of the H-4 EAD, but it only works if your H-4 has already been extended. If your H-4 is expired and you have a pending H-4 and H-4 EAD renewal, that does not make you qualified for the auto extension. How can you become qualified for the auto extension? Depends on when you filed, and you need to take action before your H-4 has expired, because in that situation, if the H-1B has already been approved to extend for the next 3 years, you may be able to travel to Mexico, showing your spouse's H-1B approval when you come back, and then they'll give you a new I-94 extending your H-4 without you having to do anything. But there's very particular criteria for that to work, so you might want to check into that. We've got a couple of videos about it here on our YouTube channel as well. But just having the H-4 EAD application renewal pending by itself without an extended I-94 does not allow you to keep working.
My My EAD got approved along with the advance parole. The card says that it's valid for advance parole. However, the advance parole receipt notice, when I type in the USCIS website, it says it's still pending. Can I travel based on the EAD, which is an advance parole approval on it? The answer is yes. We see sometimes the online is not accurate, but if you have a card which says that it's valid for advance parole, you are fine, and the date is still valid. You can travel. We absolutely see no problem with it at all.
Kieran says, my last extension is valid till 6/4. My employer filed my case and it reached the lockbox on 6/4. Still haven't received a receipt notice. And then can I change my employer during this process? So it's definitely unusual that you haven't received the receipt notice by now. I would definitely check to see if at least the filing fee check has been cashed, because although we've been seeing some delays in receipts, 6 weeks is a bit much. And even if it's delayed 6 weeks, we usually will get the check cashed within a week or two. So if the check has not been cashed, there may be something else going on there. It's possible it got rejected for some crazy filing fee issue. As far as changing employers, because until your extension is approved, you're not actually in H-1B status. You're only in a period of authorized stay based on the pending H-1B. So if you were to file a transfer now, where you don't even have a receipt notice, you need to file it for consular processing, wait until it's approved, get the approval, exit, get the visa stamp, come back in, and only then can you start work for the new employer. If you actually do have a receipt notice, you could potentially file a transfer, but your transfer is going to be dependent on getting this extension approved. So if the extension gets denied or the employer withdraws it because you've left, it's going to create a gap, and the bridge is going to collapse. Your pending extension is called a bridge. So definitely not the best time to change employers.
Question from Jayant Kumar. Their 485s are pending. Can they transfer to the US consulate in India and get the green card there? Technically, the answer is yes, you can. The company can request the USCIS to send it for interview in the consulate, though. Although it takes a long time, that's number one point to be considered, because you have to file an application called I-824. The second thing to be considered is that you must have the company that you're working must be cooperative. If the company change, or if you don't have a job with that company and the company is not cooperative, it may create a problem for you. Question is from Karthik Kadapelli. His advance parole is approved for 5 years, but his EAD renewal is under process. Can he travel outside the country using the advance parole? Will it cause any problem for the EAD? You can travel on advance parole. Absolutely not a problem. Your EAD will be adjudicated. Your travel will not have any negative impact, none whatsoever at all, on your EAD extension.
Chandrakrant says, my brother's on an E3 visa. Does he need to go for stamping when he changes his employer while staying in the USA? So the E3s are for Australian citizens. It's very similar to an H-1B, but it does not always require that a petition be filed with USCIS. So the normal, easy way to get an E3 is the company gets an LCA, just like they would for an H-1B, and then you go straight to the consulate, apply for the E3 visa, and come into the US. There's no I-129 petition filed with USCIS. You don't have to wait for that to get approved. But if you're in the US and you don't want to travel again to get the new stamp with the new employer can file an E3 change of employer while you're in the US by filing an I-129 petition. Most don't do it because it's easier to just travel and you don't have to pay all those filing fees that are associated with it. You don't have to pay for premium processing. Because I think E3s are not portable, so you have to wait until it's approved before you can join the new employer. So you pretty much have to file it in premium processing. It's much more expensive to do it in the US.
Sabarshi Satishivan has this question. His wife was on H-1B before on I-797A. She traveled to India and came back on H-4. He has an I-140 approved and he wants to file a H4 EAD, but it's taking a long time. It's taking a year. I would say that it's taking definitely less than a year. But what are the alternative options? Well, she can file a change of status to H1B if the company is ready, and they can file a premium processing, get it approved in 3 weeks. That's one option that you can consider. If your company is cooperative, you can file a H1B amendment in premium processing and file a H4 plus EAD along with the H1B so that everything will get approved in 3 weeks. These are the two things that I think so that can resolve the problem faster. Expensive, sometimes it requires cooperation of the company, but it's possible.
Jayanti says, can we transfer a pending 485 to the Hyderabad consulate permanently because we plan to move for good?
I did answer
you got that one already? Okay. Couple questions about priority date movement, especially for EB2, EB3. A lot of people asking, when is it going to get to January 2015? I think we've talked before, but based on the 485 inventory data, which is being updated regularly, they just published it in early July that has the numbers from April. I mean, there's still 5 years worth of applications pending with USCIS already that they need to get through before they can move the dates forward further than what they were back in October 2020. So it is not going to be any time in the near future when the dates move beyond December 2014.
Isaac has this question. He has an F1 visa. His NIW I140 got approved. He's saying that his EB1A EAD got approved. I don't know what for his wife, and I'm assuming that you got an EAD approval based on the I140 approval of either your wife's EB1A or your EB1A. Okay, either of those things. And I'm already assuming that the I-140 for EB1A, either for your wife or you, is already approved, and you have an EAD approval. In that case, though, when you have an EAD approval and your spouse or your EAD I-140 under EB1A is already approved, and I'm assuming that the EAD is based on the 485, I don't see any problem, absolutely no problem in you working on EAD. Swati has this question. We have an EAD waiting for the GC. My son is applying for a college. Will he be considered to be domestic or international? This question came out when I was doing my master's in law. I did argue that I am a domestic student, and they did accept me as a domestic student. I provided them the lease agreement, bank statements, and certain other things, and I didn't have to pay the out-of-state tuition at all. I paid in-state tuition in Texas.
I think that's about it for today. Thank you, everyone, for joining us. And as usual, we'll be back next Tuesday at 5 o'clock Central Time, and hopefully we'll figure out what's going on with the audio. Sorry about that.
Thank you very much.